We begin tonight with an admonishment from a federal judge to the Trump administration. There will be no tolerance for gamesmanship or grandstanding. That warning came as DOJ attorneys continued to sidestep questions on exactly what the administration was doing to comply with a court order requesting that it facilitate the return of Kilmar Abrego Garcia. I'm joined now by CBS immigration reporter Camilo Montoya-Galvez. Camilo, thank you as always for being here. So what else did the judge say?
John, this is truly a dramatic and extraordinary legal showdown in federal court. The federal judge in Maryland overseeing this case has now said on the record that she believes the Trump administration is actively and deliberately violating her court order, or at least slow-walking it by not facilitating the return of Mr. Kilmar Abrego Garcia, the man that officials have admitted they mistakenly sent to El Salvador despite a legal protection he had from deportation to his home country. She has now scheduled 2 weeks of discovery and fact-finding. What does that mean? Well, now she is ordering the administration to produce documents and also to make available top officials for sworn testimony as to whether or not they're truly complying with her mandate and her ruling. So this should be a really interesting next few days.
What's the administration say?
The administration is arguing in federal court and publicly in the court of public opinion that it is doing everything it can to comply with this court ruling, but they have a very narrow interpretation of what facilitate means. They say that that word, facilitate, only implies the administration allowing Mr. Abrego Garcia into the U.S. if the Salvadorian government, one, releases this man from that notorious Secot mega prison, and two, allows him to return to the U.S. But now we have learned that the Justice Department is taking the position that even if this man is brought here to the U.S., he will either face deportation to a third country, an unknown third country, or he will be indefinitely detained until that legal protection from deportation is terminated so he can be sent to El Salvador a second time.
Very quickly, has he been accused of a crime other than being
here? He has not been convicted of any crime in the U.S. nor in El Salvador.
Camilo Montoya-Galvez, thank you as always. For more on this case and the administration's response, I want to bring in Jeffery Rosen, President and CEO of the National Constitution Center. Jeffrey, thank you for being with us. Help us understand, what's your sense of the administration's response, these responses to the judge, this kind of back and forth? Give us your take on that and just kind of characterize that for us.
Well, it's really an extraordinary question of whether or not the administration is complying with an order of the Supreme Court. And the Supreme Court unanimously held that the administration must facilitate Mr. Garcia's return. The position now that he was not wrongly deported, which they conceded before the Supreme Court that he was, represents a shift, as does this rather remarkable claim that he has to show up at the border to be allowed back into the country, and that he'll be detained even if he does return. So essentially the question is, will the administration defy a clear order by the Supreme Court? President Trump said on Friday that he respects the Supreme Court and would not defy a clear and direct order to him. And yet this fact that the Maryland judge is now holding hearings about whether or not to hold the administration in contempt suggests that she thinks that they may be not abiding by her ruling. So we're coming up to the precipice of a really historic conflict between the president and the courts, but we have not quite gotten there yet.
Put it in historical context for us. Presidents have clashed with the judicial branch before. Maybe you could argue that's even part of the design. But is this at a new level? Should we think of this in a new way?
Yes. What's so remarkable about past clashes with president is that no president has defied an unambiguous order of the Supreme Court. The closest we came was during the Civil War, and President Lincoln detained a guy called Merriman. He suspended habeas corpus. Chief Justice Roger Taney said that he was wrongly held, and the administration briefly refused to turn Merriman over. They were held in contempt, but the point is that Lincoln complied. A few weeks later, he brought Congress back into session. They validated his order, and he did turn Merriman over to civil custody. So in other words, never before, not even at the gravest moments in American history, have we had a president openly defy an unambiguous order of the court. And of course, we haven't yet either. But the question is whether we're coming up to that point.
With 30 seconds left, zoom us out here, Jeffrey. The Constitution has a lot of protections for the innocent against being unjustly charged. Can you just kind of step us back there and explain why those exist?
Well, the basic protection of due process of law goes back to the Magna Carta in England, and it's why we fought the American Revolution, the idea that the president is not a king and can't throw people in jail without due process. And that's the essence of the constitutional protection for separation of powers that denies the president the ability to throw people in jail without due process. And those protections go to all people, aliens and citizens alike, as the U.S. Supreme Court has held. So it's at the very core of the Constitution, and what we're talking about are the most fundamental constitutional principles.
Jeffery Rosen, President and CEO of the National Constitution Center. Thank you so much, Jeffrey.